Hi, I'm immigration attorney Heather Poole. I'm speaking to you today about options that may be available to you if you have received a deportation or removal order. Always consult a competent, licensed immigration attorney before filing for any relief in court, so you know if you qualify for it. A removal order is a 10-year bar to re-entry into the United States. You cannot serve the 10 years required in a removal order while still inside the United States. You can apply at the end of the 10-year period of time after staying outside of the United States for 10 years to re-enter at that point. If you already have a removal order, depending on how much time has passed since the final order, you may be able to appeal the order to the Board of Immigration Appeals and even pursue federal litigation. You may be able to file an appeal of a decision by an immigration judge if you have received the removal order. The Board of Immigration Appeals hears appeals of immigration judge decisions. The immigration judge must follow the decision by the BIA. If the BIA sustains your appeal, the case is sent back to the immigration judge for reconsideration on any number of issues and potential reversal of the removal order. If the BIA dismisses your appeal, this means that you have lost your appeal. Be very careful and seek out the advice of an attorney now if this applies to you. There are deadlines for appeals. If you have waited too long to file an appeal, or new circumstances arise that qualify you for immigration relief, you may be able to file a motion to reopen with the immigration court. But this usually requires that ICE counsel join in the motion if you've missed the deadline for a regular motion to reopen. You cannot file the motion directly with the court without ICE's cooperation in a joint motion. If within the period of time for an appeal after your removal order is issued, you may be able to file a motion to reconsider the judge's decision. It is very important to speak to an immigration lawyer about your situation before you get a removal order, but if you can't afford to or do not have the ability until after you receive a removal order to speak to an immigration attorney, still do so. A stay of removal is an application filed with the court which would stop the Department of Homeland Security from removing you even if you have a removal order. You are legally entitled to an automatic stay of removal during the time you're allowed to file an appeal of the immigration judge's deportation decision in most circumstances. Sometimes you can go right to the courts instead of the Board of Immigration Appeals. This is called judicial review. If you did not attend your removal hearing, you have received an in absentia removal order. Even if you are married to a U.S. citizen and plan to consular process your immigrant visa based on the marriage, the consulate cannot approve your visa for at least 5 years from the date of your departure from the United States if you have received an in absentia order. There are ways to reopen a removal proceeding when an in absentia order has been issued, to reverse the order and later terminate proceedings. It is vital to do so before you leave the United States, if at all possible. It is extremely important to speak with an immigration attorney quickly after you receive a removal order. There may be other alternatives for you that are not discussed in this video. If you need my help, feel free to call us or complete our consultation questionnaire on our website, humanrightsattorney.com. Thank you and good luck.